everyone. Welcome to the Accommodation Atlas. Did you know you have rights at work if you get migraines or burnout is having a physical impact on you? Did you know there's a law that says people with disabilities and qualified conditions have the right to fair treatment at work and that it's been around since before your favorite 90s sitcom? That's right, the ADA, aka the Americans with Disabilities Act. Today, we're diving into what the ADA is, how it works in your job, and what 2025 court decisions are teaching us. Grab your coffee or your drink of choice. This gets interesting fast. Before we jump into that, welcome to the Accommodation Atlas, your go to guide for understanding your rights at work, how to navigate your unique needs, and advocating for yourself. It's complicated knowing where to go, what to do when it comes to the workplace, especially when health conditions come into play. Well, let Accommodation Atlas be your guide. I want to empower you to advocate for yourself and live your best life. Let's jump into the ADA. Quick disclaimer, this is not legal advice. Please consult a licensed attorney for legal advice. This is not medical advice. Please consult a licensed medical professional. Jumping in, let's rewind. The ADA was signed into law in 1990 by President George Bush. Its aim? To protect people with disabilities and qualified conditions from discrimination in many areas: employment, public services, transportation, public accommodations like restaurants, stores, etc. Think of it like civil rights law for disability. A few fun history tidbits. The ADA grew out of earlier disability rights activism. When it passed, reasonable accommodations and accessibility were central ideas, but it took many years of lawsuits and clarifications to figure out exactly how they should work. Over time, courts and agencies interpreted terms like disability, qualified individual, essential job functions, and reasonable accommodation. If you work, the part you probably care most about is Title I of the ADA. Here's how it works in practical terms. Term disability means a physical or mental condition that substantially limits one or more major life activities. It can include people being treated as if they have such a condition. Qualified individual, someone who meets the skill, experience, education, and other job requirements and can perform the essential functions of the job with or without reasonable accommodations. Essential functions, the basic duties that are fundamental to the job, not just nice extras. Reasonable accommodation, changes or adjustments to a job or workplace so that a person with a disability can do the job. Examples include flexible schedule, modified equipment, more frequent breaks, remote work, etc. Undue hardship. If an accommodation would be very difficult, expensive, or fundamentally change the nature of the business, the employer might not be required to do it. It's a balancing test. Let's say you have chronic migraines, a qualifying disability. You might request to start work later some days, or take short breaks, or have a quiet workspace. If these help you perform your essential tasks, your employer may need to grant it unless it truly causes undue hardship. So, what should you do if you need assistance navigating this at work? Consider if there are adjustments or accommodations you can make yourself at work within your control. Speak to your employer, ideally HR, about the disability or qualifying condition. Usually, you need to disclose and maybe provide medical documentation. I acknowledge there's a lot of emotions that go into this one. Request accommodations in a timely manner. Be specific what you need and why. Employers must engage in an interactive process, meaning they should talk with you, explore options together, consider your request. If your employer denies reasonable accommodation without good cause or treats disability-based issues differently, you may have legal recourse. Example, complaint to the EEOC, state agency, or a lawsuit. Now, a part that's fresh and super relevant, recent court rulings that change how some of these pieces work. A big one in 2025 was Tudor versus Whitehall Central School District. Angel Tudor is a teacher with PTSD. She had been allowed breaks during prep periods, but the district later removed her ability to leave campus in the afternoon prep. She asked for accommodation, the district denied. The court clarified that you don't have to show that an accommodation is strictly necessary in order to perform the essential functions of your job in order to request one. Even if you can do the main job functions, maybe with difficulty or strain, you still may be entitled to reasonable accommodation. Why this matters? It lowers the bar a bit for what employees need to show when requesting accommodations. It emphasizes that supports like break, schedule changes, etc., can be required even if you can technically do the job as written. It's about preventing unnecessary suffering and helping you live your most fulfilled life here at work. And most recently, the Department of Justice removed several ADA guidance documents, some about accessibility, COVID-19, calling them outdated or unnecessary. The ADA itself has not changed, but losing those guidance documents makes it trickier for both employers and employees to know what best practices are. That's where I come in. Let Accommodation Atlas help you. Okay, real talk. So, how does this affect you on the job? Here are the key lessons and what to watch out for. If you're currently employed and you have a disability or a qualifying condition, don't assume you have to prove you can't do part of your job to get help. Can perform essential functions with or without accommodation is enough. The Tudor case affirms this. Be proactive. Document your disability or limiting condition, requests for accommodation, and conversations you have. Know your rights and what reasonable accommodation might look like. Breaks, schedule adjustments, physical modifications, remote work, assistive tech, etc., depending on the job. I will be making more in-depth videos on this, so stay tuned. Employers are required to explore these unless there's a real, truly defensible reason not to. And keep tabs on legal developments and guidance. This is where Accommodation Atlas comes in. If your employer is unsure, or HR is, consider consulting outside resources such as the EEOC, state human rights commissions, legal clinics. So, reminder, this video is not legal advice, just some helpful tips from my professional experience. As a reminder, per tutor, even if you can do the essential tasks, accommodation may still be required depending on your situation. Here are some tips if you believe your ADA rights may be violated. Talk to HR or supervisor, explain your disability or qualifying conditions, request accommodation, document everything. If denied, ask why. Keep records. You might also request a written denial. Reach out to the EEOC or state equivalent or file an internal complaint per your employer's policy. Consider consulting with a disability rights attorney, especially if the issue involves benefits terminations or serious discrimination. And know the deadlines. ADA complaints have time limits, statutes of limitation, so don't wait too long. So there you have it. The ADA has been around since 1990, evolving over time thanks to court rulings like Tudor. Whether you're actively living with a health condition or curious about accommodations at work, or you're in the middle of the interactive dialogue process, these decisions can affect your rights. If you liked this video, hit like, subscribe for more content. Comment below letting me know if you want more videos on certain topics. I always want to end every video uplifting our community. Comment below with the sunshine emoji to represent shining a spotlight on your workplace rights. Let's keep making workplaces fair to everyone. Thanks for watching. See you next time.